Hi, good afternoon, everybody. Hope that you're all okay. So, welcome to those attending in the Zoom room today, and also welcome to those that's going to be watching on catch up. So today we have our LoveBiz training and development session, and this is entitled Recruit, Retain, Release, a practical HR workshop. So I have the absolute pleasure of introducing Liz Burley, who is one of my Trent members, who's delivering the workshop today from Burley Law Limited. So Burley Law is a niche regulated law firm providing IP, international, commercial, employment HR advice for businesses. She's the co-director of Burley Law and a qualified solicitor. So with 17 years experience in practice as an employment law specialist, she supports SMEs to be employment law compliant. She has, and hopefully she doesn't get many of those, but an reduced business risk. So Liz also works with HR professionals to provide broader HR services to businesses. So what I'd like to do is welcome Liz as our presenter today on our training and development workshop. If you have any questions, pop them in the chat box, everybody, and I will relay them back. So Liz, I'm going to say it's completely over to you.
Thank you. I'm in the hot seat. Hello,
you are
everybody.
in the hot seat today.
Hello, everybody who is attending today and everybody watching online. So I'm just going to share some slides to get started. So, as Jackie said, I'm Liz Burley, and I'm a solicitor, and this is what I hope will be a practical workshop for female founders in the LoveBiz community. I've been a member of LoveBiz for just over a year now, and it's a pleasure to be presenting for the first time. I've got a good idea of the sorts of issues that business owners in this community have in relation to HR. We're not running multinational businesses, but I do recognise that a number of you in the community will have worked for large companies in your previous working lives. You may even have been involved in handling aspects of HR. Such as recruitment or grievances and disciplinaries, or even termination of staff in the past. So you may have an idea of how those processes function in larger settings. But for me, the focus probably today is about what you can do as a micro business owner and what issues you need to be thinking about. Because working for a huge organisation, whether it's a corporate multinational or public sector, is very, very different to running your own business. And you don't have the support of large HR departments or HR advisors. And you have to navigate what can sometimes feel like a very complex minefield of employment rights. And as we know, employment is something that's in and out of the news daily, particularly at the moment with a new government getting ready to introduce an employment bill, which will set out a whole new raft of worker rights. They're aiming to really shift the landscape in favour of workers. So this can seem like a very daunting topic, and I hope that today I might break down some of the myths and help you understand some of the issues and the legal practicalities a little bit better, so you can be confident about hiring people. So why are we thinking about hiring people? Well, very simply, although we live in an age of technology and AI is threatening to take over the world, it remains the case that you cannot grow a business, particularly a micro business, without people. And that is my number one rule today. We have to think about who we need to help us get our business, whatever it may be, whatever product or service we are promoting, how we get that business to the next level, and also where we want our business to end up. And that's often the forgotten piece of the jigsaw when we're business planning and we're planning for who we need to recruit in the future. Where is it that we're heading to? We might think about the journey we're on right now, but do we have a business plan for the next 5 years that tells us where we want our business to arrive at, where we're heading towards, and who will we need on the bus with us. So that for me is a very key part of the picture. When we're thinking about HR planning generally, it may not be a legal issue, but it's certainly something that should be fundamental to your business planning. So how am I going to, and as Jackie's just said, please, if you have any questions, put them into the chat. I'm really happy to answer questions today, whether that's on the recording or afterwards. So our next slide, we're just going to move the slides on. Okay. So to make this practical, what I've done is draw on my knowledge and experience of many, many years of advising on the legal end of HR issues to pull together a case study and make it scenario based. So that's what we're going to look at. And just so you know a little bit about the experience I bring to this. So I qualified as a solicitor in 1995. Way back before mobile phones were really getting going, and certainly no computers at the desk. But in that time after I qualified, I specialised immediately in employment law. So I was handling cases involving unfair dismissal, redundancy, discrimination right from the get-go. I had a 10-year break from legal practice between 2004 and 2015 when I didn't do any legal work. So when I came back to legal practice in 2015, it was as an employment specialist, but as you can imagine, there was a lot of groundwork to do to get up to speed with some of the changes that had happened in employment law, but also cut my teeth again. So since then, I've handled a whole range of legal issues around HR, whether that be on unfair dismissal, discrimination, whistleblowing, constructive dismissal, grievances and disciplinaries, data protection, you name it, I've probably dealt with it over the last nearly 10 years. So I bring to this quite a lot of knowledge about how things can end up at the sharp end, and I suppose that's really the focus of the case study that I've put together. It's helping us think about where things might end up, so that we get our decision making and our prioritising and processing and our structure around recruiting, retaining, releases right from the get-go. So our case study starts with Sarah, who is the founder of a business called Nutrify Her. And this is a business selling nutritional products tailored around women's health. She's been working on her own for 2 years and her business is getting some traction in the market. She's got customers and she needs help now to scale the business and also to handle those customer orders. So her plan is to hire 2 people, but she's unsure whether to hire full or part-time employees or freelancers and contractors. So the first thing we're going to think about here is why we should hire employees or freelancers and contractors, and what does it mean? What's the difference between them? So if you've been in the business of HR before, you'll know that there is a fundamental difference between employees and the self-employed for the purposes of employment law rights. So an employee is generally viewed as, for the law, somebody who's bound by a contract of employment, and we sometimes call that a contract of service. They owe contractual obligations to their employer to turn up for work and perform in a certain way and deliver certain duties, and in return they get paid. And there is a lot of certainty around that relationship because the employer knows what to expect and the employee knows what to expect, and the relationship can't be broken without one or the other giving a minimum period of notice. And the employee has various statutory rights, which we'll come on to think about. Now, on the other hand, a freelancer, or sometimes we call them an independent contractor, or we might also call them a consultant, is a self-employed individual. That means that they run their own business on their own account and they undertake contracts for services. That's the key difference. They might, and some of you in the community in LoveBiz might operate as freelancers, in which case you'll know that you're running your own business. You might be a sole trader, or you might operate through a limited company. You organise your work, you decide the terms on which you offer your services to your clients or customers, and you are free to decide who you work for. You can start and stop working for a client at any time, and you decide the terms on which you offer that service. You pay for your own equipment, you pay your own taxes, you're responsible for your own pension, and you don't get holiday or sickness payments from anybody. You have to, if you take a day off sick, you take the hit, and your business suffers that loss for the day. You might be able to send substitutes to work for the client if that's part of your agreement with them. But those substitutes that you send if you're not well, if you're on holiday, you're away from your business for any reason, would have to be hired by you as subcontractors. So that's the fundamental difference between the two concepts of employment versus self-employed. And I just wanted to stop and ask a question at this point. About whether you think any of these are self-employed or employees for the purposes of employment law. So you don't need to answer out loud. You can put it in the chat if you want. I'm not looking at the chat, by the way, but I'll just go through them and I'll give the answer once you've had a think. So which of these would be an employee for the purposes of statutory employment rights? An intern? That might be a student coming from university just to get some work experience, working for a period of time, maybe a few months. A director of a business, a volunteer, a partner in a business, and a franchisee. So let's take the intern. Employee with statutory employment rights? The answer is possibly. It all depends. If you are hiring an intern to do paid work in your business, and you are expecting them to turn up regularly and deliver certain duties, the chances are they're probably an employee. At the very least, under statutory law, they'll be a worker and entitled to a lot of the rights that an employee would have anyway. If they're not paid, they probably look more like a volunteer, but you can't rely on them to turn up, and you can't demand that they work in a certain way or follow policies. You can't discipline them if they're purely a volunteer. So interns are quite a special category. If you're getting them to do productive work, you should be paying them. They're probably a worker. They might be an employee. A director of a business, well, they're not an employee automatically. They are what's known as an officer of the company. Each limited company has to have 1 or 2 directors, and those are known as officers of the company, but they might also be working day to day in the company, in the business. If they are, then there's a high probability that they're also working under some kind of employment contract, but their director status itself does not give them status as an employee. It all depends on what they're doing as an executive or non-executive role. Thirdly, a volunteer. Well, as I touched on with the intern, a volunteer is somebody who doesn't have to work any particular minimum number of hours. They don't have to turn up. They literally do so on a volunteer basis. It's up to them when they come and go, and they're not usually paid. You would not expect these people to be employees. However, employment law can decide that a volunteer, even if they're named a volunteer, has become an employee purely on the basis of the factual context. So if the relationship is such, if the expectations are such, and if that person has been working reliably, consistently within a business, or more likely a charity setting, the law could decide that they've become an employee through circumstances. A partner in a business, well, they're not an employee. Partnership law is completely separate to employment law. Partners are self-employed people. And finally, a franchisee. Well, there again, a franchisee takes, for example, if we take, for example, McDonald's, each McDonald's store is owned and run by a franchisee. They are self-employed business people. They might have a limited company through which they operate the franchise, but they're not employees of the franchisor. So thinking about what's best for you and your business, if you're Sarah and you want to hire your first hires, there's no legal requirement here to go either way. So you could decide that employing your first hire is the best thing, depending on what your business needs. If you're looking for somebody to work on key day-to-day business operations, whether that's admin or sales, marketing, delivering services, and you want that person to grow with your business, and you have certain expectations of how they'll operate, the values that they bring, and whether they're aligned with the value and the brand of your business, then you might just want to consider hiring them as an employee. Yes, that's going to have increased cost for your business because you're going to have to pay salary plus employers' national insurance. You'll have obligations to enrol them in a pension. They'll be entitled to holidays paid and SSP as a minimum if they're off sick. So there are lots of extra costs that are hidden with employment that you need to know about before you go down that path. Those costs don't apply if you're hiring a freelancer, because as I said, freelancers are responsible for their own tax, national insurance, pension, sickness. So you wouldn't have that additional cost to your business. However, it's more likely that you'd want to hire a freelancer if you're looking for somebody to bring particular expertise to your business. That might be on creating a brand campaign, or it might be to help you with financial and business planning for your 5-year plan, for example. It might be that you're looking to gain traction in a particular market and you need a sales expert to lead that sales campaign. So project-based work is more likely to be suitable for freelancers or contractors, where you need expertise that you can't grow organically in your business. However, you need to be aware that any freelancer can come and go. They have flexibility to choose who they work for, so they may not be available to you in the future if you decide you want to continue working with them. So that's an overview of what sort of some key considerations. I wanted to touch just on recruitment processes generally, if you're thinking of hiring an employee, and what you need to have in the front of your mind. Now, there are lots of things that big employers do and to make their recruitment processes rock solid, to make sure they're getting the best people and they are assessing people fairly within the law and all of that good business. However, as a micro business, you're not going to have those resources available. At the very minimum, to ensure that your recruitment process is both fair and compliant with the law, but more importantly, that you're hiring the best person for your business, you need to do some preliminary steps before you even get as far as advertising. So within your business plan, you really need to think about what that next hire, or maybe even what the next 2 hires would be, what roles that they'd be carrying out, and you need to write a job description before you do anything else, because that job description will shape your recruitment process. It will also give you a plan, a basis on which to monitor performance and delivery from the employee that you hire. So it's both useful during recruitment, but also afterwards, once you've got that employee in place. And you need to understand that they are delivering against the expectations that you have and what they've promised. So the job description is fundamental. You need to decide where you're going to advertise for the role, and you need to consider the kind of person and the skills and qualifications they would need to bring to the role. So a job description, advertising channels, and a person specification. And of course, your written advert. So those are all the things you need in place before you go anywhere near the marketplace to recruit. And then, of course, you need to work out what your recruitment process is going to be, from advertising through to making that offer. And once you have decided who you're going to hire, fundamentally important is an offer letter setting out in writing the terms of employment offered, the conditions that apply to that offer, and whether or not a separate contract will be issued for them to sign before starting employment, or whether the offer is indeed the contract itself. If you're going to use the offer letter as your contract, you need to make sure that all terms, particularly those that are required under law, under Section 1 of the Employment Rights Act, are covered in that letter. So it might be better to think about having an offer letter template that is the headlines, the principal terms of the offer, like pay, hours, holiday entitlement, any benefits that will apply, start date, any conditions like references, and then make that offer subject to the full contract, which will follow once you've got acceptance of the initial offer. So those are some initial considerations around recruiting well. Of course, they're not the whole picture, and I understand there's a lot more to think about, but good key principles to bear in mind. So we're going to move on then to think about what happened next for Sarah, because she decided to hire a freelancer and a full-time employee. Now, her freelancer is a lady called Jane, and she is hired to do some social media work for Sarah and for Nutrify Her. So she's working as a social media manager on a casual basis, so self-employed, presumably invoicing for her services, maybe on a month-by-month basis. Also Sarah hires Emily, a full-time administrator, to help with the processing of the customer orders, keeping the customer database up to date, and invoicing, etc. So Sarah provides Emily with a full-time employment contract, but Jane, being a freelancer, didn't get any kind of contract. Sarah didn't think she needed a contract because she's not an employee. So the basis of the relationship is purely verbal. Both Emily and Jane have access to Nutrify's business systems, so the IT system, all the information that's needed to help them do their roles. So some months into working with Jane, Sarah discovers that Jane has been using Nutrify's business information and specifically customer lists and marketing strategies. And she has been working for a competing nutrition brand that she's also been freelancing for. Now Sarah is faced with possible damage to her business, and she's got to decide what steps she can take to deal with Jane and what's happened. Now, there are some key legal issues for me about this scenario, which I want to highlight because they're really, really important to engaging with freelancers. And they're things you need to think about at the get-go, not further down the line. So the relationship with Jane is verbal. There's no written contract, which means that there's no written agreement about Jane's access to what Sarah considers to be her business confidential information, or the business confidential information of Nutrify Her. So Jane has full access, as we know. There's nothing in writing. There's no, some of you may have heard of non-disclosure agreements. They're in the news quite frequently at the moment, thinking about sexual harassment cases and how they're used there. But a non-disclosure agreement can be used in any business scenario where two or more parties agree that certain information must remain confidential within that relationship. So an NDA could be used with a freelancer, even if there's no other written agreement about how they're providing their services and payment terms, etc. A simple NDA could have been used by Sarah to protect the confidential information in her business that Jane has access to. Probably more broadly, Sarah should have thought about having a full written agreement with Jane, what I'd call a freelancer or a contractor agreement, setting out the basis of the relationship, all those other things I just talked about, and confidentiality obligations. Now, the really important legal point here is that if you engage with a freelancer, they're self-employed, they don't owe you any legal duties whatsoever. They don't owe the same duties as an employee. And one of the key legal duties that an employee owes to an employer is that of trust and confidence. And the word confidence is important here. So an employee has a general duty in law to keep confidential matters relating to their employment and their employer. There's no such obligation from a freelancer. They're free to do what they want. So if they have access to your systems and they decide to use information, you will have a tough time pursuing them through a legal letter or through court action if it came to that. So from the get-go, you need to have a freelancer agreement that includes confidentiality obligations from that freelancer to your business. But within those obligations, you need to carefully define what you consider is confidential information to your business. And that will depends on the business that you're running. You might consider it to be a marketing strategy. You might consider it to be recipes for a product that you sell on the market. You might consider it to be customer lists and pricing. You are free to specify what that information is in the contract with the freelancer. Without that contract, further down the line, should there be a dispute about whether information was confidential and the fact that it's now been taken out of the business, you will have a very hard time recovering that information and stopping them from using it. So really important, key lesson for Sarah is to have a written contract with Jane, specify what the confidential information is in her business and what Jane can and can't do with that information in carrying out her role for Nutrify Her. The other thing that Sarah didn't realise, of course, is that Jane was carrying out freelance work for a competing business. Now, it's very difficult to restrict freelancers in what they do for other businesses. They run their own business, they're free to contract with whoever they want to. And if you start to impose restrictions on what a freelancer can do during and after their engagement with you, you might start tipping into an employment relationship, which is not what you want. However, there should be very clear agreement, written terms about what happens to confidential information during the relationship, and that part of your agreement with them should specify that their confidentiality applies indefinitely after they finish working for you. So that's completely fine. It won't tip you into employment law, and it's very important for your business that that is in your agreement with them. Why? Because if that promise is broken by them, you have a breach of contract claim that you can pursue legally, initially through a cease and desist letter, for example, and then if that doesn't resolve it, you can then go on to escalate it through legal action. You need to be able to prove loss to your business, and that can sometimes be tricky, but without that written obligation from them, you won't even be able to get a legal case off the ground. So key takeaways from that is make sure you've got your contracts in place before you hire the freelancer, so a freelancer template, or before you hire your employees. I mentioned briefly employees there, the kinds of duty they owe generally in confidence, trust and confidence to your business, and duties of faithfulness. However, most employers will not rely on those general legal duties. They will want to have a robust employment contract that is very clear with employees about what they can and can't do in terms of working for the businesses or having an interest that might conflict with the business they're working for your business, and what they can and can't do in competition with your business after their employment with you ends. Those are things that you can restrict employees on, which is different to the situation for freelancers. So those key aspects of employment contracts need to be covered. And in terms of templates, just a word on that, you may find some really useful templates on the ACAS website, and I can share a link there at the end in the chat. But employment contract templates tend to be very basic. If you draw them off ACAS, they will cover the bare minimum. They may not protect your business on these key areas like confidentiality and intellectual property, which we're going to come on to look at. And they certainly won't have restrictions against working for competitors after employment ends. So do make sure that you take professional advice from a HR advisor or a solicitor like me on whether your contract of employment is robust enough to protect your business from competitive behaviour. So, and finally, a word on confidentiality, which is often we talk about having the paperwork in place, that's the contract, covering all these good things. But we get very lazy about our access to systems. So if you have, well, all businesses have information stored on the cloud or locally on devices that is key to the value, the commercial value and the commercial operation of the business. If you're seeking to protect confidential information, business proprietary information and trade secrets, you should think very carefully about who you give access to those areas to. So access should only be appropriate to the role that that person's carrying out, whether they're employed or freelancing. Think about access to particularly sensitive documents or processes, making sure things are encrypted, password protected, and think about levels of access, because should it ever get as far as a legal case, that is what a court will be interested in. Not just the piece of paper that says you keep things confidential, but they'll be interested in what has been leaked out of the business and whether you took sufficient steps to protect your business from that leakage. And that, of course, applies to how you manage your systems and protecting your business proprietary information. Think about it like your house. We wouldn't dare go out of our house and leave the door open and signpost thieves to where they can find our key assets, our jewellery, our keys, our laptops, whatever it may be. Think about your business in exactly the same way. Batten down the hatches and make access available only to those who need it and for the purpose of their role. So we're going to move on to look at another scenario. I'm going to skip over case study 3 and go straight on to 4, please, because we're going to run short of time. So we're just going to roll back the slides. Just bear with me. Go to 4, please. We're going to go on to 4. Thank you. So I've skipped over case study 3 because I'm not sure that we have time for it, and I want to get on to thinking about intellectual property ownership. Now, I've talked about confidential information, but confidential information and intellectual property are not always one and the same thing. Now, Sarah has received an offer from a huge wellbeing products company who want to acquire her healthy vitamin products, one of the lines she sells. Now, for Sarah, this is a great opportunity. It would be a brilliant deal, and it would, frankly, make her rich and would be her exit plan for the business. As part of the deal, the buyer has asked that all intellectual property in Healthy Vita products must be assigned by Nutrify Her Limited to the buyer. That's perfectly normal in commercial deals like this. But when Sarah looks at the fine detail of what intellectual property she owns, she's not sure. She's not sure she owns the IP in the designs and in the logos and depictions of the products, because she hired a freelancer to create and design them, the advertising and the labels of the products. So she's also not sure if she's got the right to sell the recipe of the vitamin products, because she received that from one of her employees, but the employee worked on it, created the recipe in her own time and using her own equipment. So it wasn't done in the office during working hours, it was done in her own time, and she gave the recipe to Sarah. Sarah's not sure that she owns the intellectual property that needs to be assigned to the buyer, and this puts the deal at risk. So what can she do to make sure that the sale can go through? And also, what can she do to make sure she's not in this position again in the future if she wants to sell another line of her trade? So, key issues here, and these again are legal issues. Does Nutrify Limited own the IP that it needs to transfer, both in the designs and logos and labels and in the recipe? Now, because Sarah hired a freelancer to do this work on the design labels, etc. The IP ownership sits with the freelancer. The ownership of IP only sits with a business if it's created by an employee of the business under a contract of employment and during the course of their employment. So, doing the job that they do, that they're employed to do during working hours on equipment that's provided for them to do their role. So because this IP was created by a freelancer, it is not automatically owned by Nutrify Her. What Sarah will need to do next is to ask the freelancer who created it to transfer that IP to Nutrify Her through an IP assignment, and that has to be a written document that's signed. Now, the problem Sarah will face here, of course, is that the IP was created in the past. The freelancer isn't probably working for the business now, and Sarah is going to have to ask for the IP to be assigned. The freelancer may want payment at the very least to assign the IP, but more importantly, she might say no, or the payment she wants may be so high, so big that it's disproportionate, and probably Sarah decides that it's going to stop the deal because she can't afford to pay that amount to get ownership of this IP. So this has a real commercial impact for Sarah. It affects her commercial success, and it's too late to do anything about this potentially after the ship has sailed. So what should Sarah have done differently at the beginning with the relationship with this freelancer? She should have had an express assignment clause, either as a document in itself. An assignment, an IP assignment can just be a written signed document on its own, or it could be part of a freelancer agreement. So the assignment clause would acknowledge that IP that's created by the freelancer as part of the work that they're carrying out, the services they're carrying out for Nutrify Her, is assigned to that business, because without that IP will be owned by the freelancer and it will be theirs to sell to to Nutrify Her. Nutrify won't be able to do anything with that IP without the transfer of that IP. Things can become more problematic legally when it concerns artistic works and copyright. So you need to have a particular professional advice if there is a dispute about who owns artistic works. Coming back to the other piece of IP that Sarah isn't sure she owns, this was created by an employee. So all is well there. Employees who create, IP that's created by employees whilst doing their work for the employer is automatically by law owned by the employer. So Nutrify should have no problem here, except we know that the recipe that created the vitamins was created by this employee in her own time, using her own equipment. It was given to Sarah, but looks like it was not within the course of her employment, within that employment relationship. This creates some risk that the business does not own the IP. So again, the only way that Nutrify Her can be sure that it owns this IP is to ask the employee to sign an IP assignment. And this would have to be a document in itself, a contract that says this IP specifies what it is assigned by the employee to Nutrify Her, and it has to be signed by her. So there is a grey area here, which I've highlighted for you about, it's relevant really to employment contracts and ways of working. So if an employment contract usually, doesn't always, and this needs to be checked in your employment contract template, usually specifies that IP created during the course of employment is owned by the employer in that relationship. But the ways of working sometimes mean that employees, particularly now, are not just working for one employer. They might be working several jobs during the course of a working week, and they may create stuff in the course of working for other employers or in their own time because they're interested in this stuff. And that's stuff that's created could have IP in it that you want to rely on for your business. So I personally would advise that in your contract with somebody who's employed with you to work, for example, as a product specialist, you make it known that they have a special interest, that your business has a special interest in any IP that they create, whether it's during their working hours or in their own time, that relates to the role they are carrying out for you. And that will give you better protection if there's any dispute about who owns something that they have created that's not specifically during their working hours. And also, the second point is that your contract of employment should put an obligation on them to assign any IP created that is not owned by the business automatically. And that will provide more protection for your business, because if they refuse to do that, and you cannot rely on intellectual property, they will be in breach of contract. You will have a legal claim against them. So that's quite heavy legal stuff around ownership of IP, but it is really important because much of the value of your business is in what you're creating and how you're creating it, or in the service that you're delivering, how you're delivering it. And when you come to think about your exit plan, you will want to rely on that value to value the business. If you're thinking about a trade sale, or if you're thinking about licensing as a model for growing the business with a view to exit, if you're thinking about franchising a product or a service, these considerations about confidentiality and confidential information and ownership of intellectual property will be crucially important, because what you don't own, you can't sell. What you don't own, you can't license. So those are some precautions around intellectual property ownership. And I think with that, I'm going to finish and say thank you for watching. Here are my contact details and the website for our business, Burley Law. If you want to email me, there's my email address. And if you want to connect on LinkedIn, you can search my name. I don't think those are links that you can click on there. Our next webinar, which I want to just say a word about, is coming up in October, and we're going to talk about harassment at work, and that's on the 16th of October. And if you'd like to know more about that, please do email me or contact me on LinkedIn. Thank you for listening.
Liz, thank you so much for that. There's lots there that I hadn't got a clue about, and it's really interesting to listen. Can I just quickly ask, what are by law, what are the policies that you have to have within a company by law?
For employees?
Yes.
So by law, there are very, very few policies that you have to have. We'll start with every employee has a right, and every worker has a right to a statement of their terms of employment. And within that written statement, certain things must be covered. One of those things is how disciplinary issues will be dealt with, or how they bring a grievance. Now, most employers, that you can either put that into a written contract, but most employers decide not to put it in a contract, and they have a policy. So a grievance and a disciplinary policy is probably a minimum. And the other policy that an employer must have if they've got more than 5 employees is a policy on health and safety. Those are the minimum policies by law that must be covered. Most employers decide to have other policies for protection of their business. So, for example, use of IT systems, use of confidential information, bullying and harassment. If you've got more than 1 employee, you probably think about policies around relationships with other employees and workers, and things like data protection.
Perfect.
Probably should be covered.
Perfect, thank you. There was just one of the things, well, I know that if you've got a company, I mean, I know Gail's on here with regards to an MLM company and this team. Is there anything by law that an organisation has to provide with regards to team, or as in?
So if you're in an MLM, multi-level marketing organization, you'll be self-employed. So there's going to be, I imagine, within that business, there will be usually some written terms as between the organisation that you're working for and you as a representative of that business, let's say. So there'll be a contractual relationship, and whatever terms are in that contractual document will apply. Yeah, so if it's about how you get paid, commission you earn, access to support, admin support, for example, the use of the brand name, those kinds of things. Beyond that, if you are self-employed but working regularly in a business, there's a possibility you could become what the law names a worker, and that has a statutory definition. I suspect in an organisation like Tropic Skincare, for example, that is not going to be the case. All representatives will not be workers. They'll be truly self-employed individuals running their own business, and those two things are different. So if you're a self-employed business contracting with that MLM organisation, the only duty that the organisation will owe to you as a self-employed person will be not to discriminate against you, not to treat you less favourably, but that the discrimination law is not general. You have to have what's called a protected characteristic, a particular characteristic that means that you're treated unfavourably, less fairly because of that. And for example, disability, age, sex, sexual orientation. So that's specific to discrimination law.
Perfect, thank you, thank you. So Lisa, I just want to say thank you so much for doing the workshop today. It's so interesting. It's been really interesting to hear. I'm actually going to stop the recording now, and if there's anybody here that's still on the call would like to ask any more questions, we can do that. But I want to again thank you so much, and it's been an absolute pleasure having you on as our training and development workshop presentation. Thank you.
Thanks. Bye.
That was really interesting. Really interesting.